Hello everyone. Today we talk about something that touches almost every family in India. It gives some people a sense of safety and causes big fights for others. I am talking about ancestral property. What is it really? Simply put, it is property that has been passed down through the male side of a family for 4 generations. Think of it like this: your great-grandfather owned a piece of land. It then went to your grandfather, then to your father, and now it comes to you. This unbroken chain of inheritance from a common male family member is what makes a property ancestral. The moment a person is born into a Hindu undivided family or half, they get a right to this property. This right is not a gift from their father or grandfather. It is a right they have from birth. The head of the family, known as the Carter, manages this property, but he cannot sell it or give it away as he wants. He is like a caretaker, not the full owner. Before we get into the important court cases, we must first understand how things were before them. For a very long time, the rules of ancestral property were guided by old Hindu law, specifically the Mitakshara school of law. Under this system, only male members of the family were considered coparceners. So from the moment a son was born, he automatically became a co-owner of the family's ancestral assets. The women of the family, mothers, wives, sisters and daughters, were not coparceners. They had a right to be taken care of using the family property, but they could not ask for a division or claim a share as an owner. A daughter, when she got married, was seen as joining her husband's family. Her connection to her father's ancestral property was legally cut off. But this left women in a weak spot. What if their marriage broke down? What if they became a widow? Their money situation was often shaky, depending on the kindness of others rather than a legal right. The Hindu Succession Act of 1956 was the first big try to write down these laws and make them more consistent. However, it did not change the old coparcenary system for ancestral property. This brings us to perhaps the most important decision on ancestral property in recent times. The case of Vineeta Sharma versus Rakesh Sharma, decided in 2020, cleared up years of confusion. The confusion came from the Hindu Succession Amendment Act of 2005. This change said that daughters would have the same rights as sons in ancestral property. They would be coparceners from birth. In this very important case, the Supreme Court finally settled the argument once and for all. A group of 3 judges gave a clear and strong decision. The court said that a daughter's right to ancestral property is a right from birth. It does not depend on whether her father was alive or not on the date of the 2005 amendment. This ruling gave power to millions of women across India, giving them a legal tool to claim what is rightfully theirs. It completely changed how family property works, putting daughters on an equal level with sons in the eyes of the law. This decision is a strong confirmation of the idea of equality in the Constitution. The court basically said that being a man or a woman can no longer be a reason to treat people differently when it comes to inheritance. Now, let's look at another very important point. What happens when an ancestral property is divided? Does it stay ancestral in the hands of the person who gets it? The Supreme Court has made this very clear. In the case of Uttam versus Saubhag Singh from 2016, the court looked at this exact question. It decided that when an ancestral property is split among the members of a joint family, the part that a person receives becomes their own property. Let me explain this with an example. Imagine a father and his 2 sons have an ancestral property. They decide to divide it. The father gets 1/3, and each son gets 1/3. The 1/3 share that a son receives is now his own property. His own children, meaning the grandchildren of the original family, cannot claim a right from birth in that specific share. The ancestral chain is broken at the point of division. The son is free to sell it, give it away, or write a will leaving it to whoever he wants. This ruling stops property from being stuck as ancestral for endless generations, allowing people more freedom to deal with their assets. The complicated nature of family structures often leads to more questions. What about children born outside of a proper marriage? Do they have rights in their father's ancestral property? The Supreme Court addressed this sensitive issue in the case of Ravanasiddhappa versus Mallikarjun from 2023. In a very important social ruling, the court said that children born from marriages that are not legal or can be cancelled have a right to inherit a share in their parents' property. The court based its decision on the idea that a child should not be punished for how they were born. This is a kind and forward-thinking way of understanding the law, aiming to give social and financial safety to all children. Another very important case is Danamma, also known as Suman Supur, versus Amar from 2018. This case happened before the Vineeta Sharma judgment, but helped set the stage for it. The Supreme Court, in a decision looking to the future, ruled in favor of the daughters. It said that the goal of the 2005 amendment was to give daughters equal status as coparceners. So what should you do if you are dealing with an ancestral property issue? The first and most important step is to gather information. Knowing things is your best tool. You must trace the ownership of the property back at least 4 generations. Visit the local land office or the sub-registrar's office to get official copies of old property records, often called the title deed or sale deed. Second, talking within the family is key, though often hard. Before rushing to court, try to start a conversation with other family members. It is always better to try and reach a family agreement or a division paper in a friendly way. If talking does not work and you believe your rights are being denied, you must get legal advice right away. Do not wait. There are time limits for filing property lawsuits. Your lawyer can send a legal notice to the other family members stating your claim. If the notice does not lead to a solution, your lawyer will guide you on filing a lawsuit for division and possession in the right civil court. In short, the rules for ancestral property rights have changed a lot. The Supreme Court, through a series of important decisions, has made the law more fair and equal. The message is clear. Daughters have an equal right from birth. Property stops being ancestral when it is divided, and even children born outside a formal marriage have inheritance rights. For families, the advice is simple. Know your rights, keep good records, try to solve problems by talking, and do not be afraid to get legal help to claim what is rightfully yours. In the complex world of inheritance, being clear and acting on time are your best helpers.